Hello everyone, my name is Ananya Rajput, a law intern at LEXIS and Company. So today in this video, we are going to talk about euthanasia. Now every human is desirous to live and enjoy the fruits of his life till he dies. But sometimes a human being is desirous to end his life by use of unnatural means. While suicide denotes the manner by which a person ends his life by his own acts, the intentional termination of a patient's life by act or omission of medical care is called mercy killing or euthanasia. The Encyclopedia of Crime and Justice defines euthanasia as an act of death which will provide relief from a distressing or intolerable condition of living. This decision may involve direct intervention like active euthanasia or withholding or life prolonging measures, which is known as passive euthanasia. If it is with the patient's consent and he has consciously and expressly approved of the decision, it is known as voluntary euthanasia. Where the individual concerned is not aware of the decision and has not consciously and expressly approved it in advance, it is called non-voluntary euthanasia. There has been a lot of debate over this topic in the past few decades. One school of thought argues that right to dignified life should be recognized as a part of basic human rights. Life does not only mean life with flesh and bones, but a life with full human dignity and honor. If a person cannot live with this honor and dignity, he or she should have the right to medical assistance in dying. Therefore, more emphasis should be laid on quality of life rather than the sanctity of life. It is argued that the word right to life is, as mentioned in Article 21 of our Indian Constitution, should embrace in its ambit the right to have good health, and if it cannot be achieved through all possible means, then it should also include right to die peacefully with medical assistance. It seems unconstitutional, a law preventing doctors to provide a lethal dose to terminally ill patients who have given their consent for the same for dying. But the counter argument to this is that for allowing euthanasia, the law of consent needs to be changed. Presently, Section 87 of the Indian Penal Code lays down that consent cannot be pleaded as defense in a case where the consent is given to the cause death or grievous hurt. As regards to death, the restriction is absolute and unconditional. Through consent may have the effect of reducing the gravity of offense. It is also argued that the resources of the hospital are very limited in our country, and thus the chunk of these resources which are wasted for the treatment of terminally ill patients should instead be utilized for the health care of other citizens who, if provided good treatment, might have many years of useful and fruitful life ahead. However, this argument cannot be accepted on the ground that in a welfare state, providing a better health care is the responsibility of the state, and nobody, even at its deathbed, can be denied this facility. However, once legalized, the high cost of medical care could induce the state or family members to convert voluntary euthanasia to compulsory euthanasia. To date, no consciousness has been reached, which makes one question the possible role that law can play in resolving this issue. It has on occasions been claimed that the court are ill-equipped to deal with the high sensitive and rather ambiguous concept of euthanasia. It is to be the efficacy of statutory regulation is to be doubted, especially when it is considered that the courts would be required to use their discretion in applying such statutes to the inevitably diverse and unforeseeable range of cases which comes before them. Society has reached a critical stage, being asked whether in the name of the mercy or self-determination one of the oldest of medicine's prohibition should be overturned, or whether in protecting its traditional role of only healing life and not taking it, the prohibition should be upheld. At stake are some of our most important ethical, legal, and social issues. Thank you.